Good morning to all of you. Today we are going to discuss about the one of the most and very important questions relating to the Indian Constitution too, that is Article 368. The question on Article 368 is likewise, examine the scope of the power of the Parliament to amend the Constitution and Article 368 of the Indian Constitution in the light of decided cases. So 368 article is very important, and so it speaks about the Parliament's power to amend the Constitution. So while power is given to Parliament under Article 368, whether it is a limited power or unlimited, and Article 13 also very important while we discuss about that, because it is a contradictory to the 368, that is Article 13. That's why we have to be discuss these articles with the landmark decided cases. So many cases were decided regarding this article, and we can say it is one of the tension between the Parliament and judiciary. So who is the supreme? Whether it is nothing but a long journey, or we can say long dispute between the Parliament and judiciary regarding the Article 368. So, as we know, the Constitution of India is neither completely rigid nor completely flexible. To meet changing social, political, and economic needs, the Constitution makes provide a procedure for amending under Article 368. Because as we need, we can change it according to convenience, and we can change the provisions given under article under Constitution by the help of Article 360. The Parliament has the power to amend the Constitution, but the extent or scope of this power has been a matter of constitutional judicial interpretation. As we know, the major constitutional issues has been whether the Parliament can amend every part of the Constitution, especially fundamental rights, and whether there are any limitations on the powers. The Supreme Court, through a series of landmark judgments, has clarified that the nature and extent of the Parliament's amending power, we can say. Thus, the scope of the Parliament's power under Article 360 can be understood only through the decided cases. So, before going to discuss in detail, first we should know meaning and nature of Article 360. What is Article 368? So, the meaning and nature of the Article 368. Article 368 of the Constitution deals with the power and procedure for constitutional amendment. So what is the procedure for amendment the Constitution? As we know, the Constitution can be amended in three ways. The first one is amended by the simple majority, amended by the special majority, and amendment by special majority plus state ratifications. So simple majority, as we know, some provisions can be amended by simple majority of the Parliament and are technically outside the Article 368. For example, creations of new states with the simple majority we can change. Alteration of the boundaries and states with the simple majority we can change. Citizenship provisions, it is also by the simple majority. And salaries and allowances of the constitutional authorities also can be made change by the simple majority. Now the second is amendment by the special majority. So Parliament has a power to amend the Constitution by the special majority. Most of the constitutional provisions are amended by the special majority, such as majority of the total membership each house and 2/3 majority of members present voting. So special majority means majority of the total members of the each house and 2/3 majority of the members presented and voting. So that's why we can say it is a special majority. And third one is amendment by the special majority plus state ratification. Certain federal provisions require ratification by at least a half of the state legislature, These includes the elections of the president, to power of the Supreme Court and High Court, so distributions of legislative power, so representations of states in the parliament, and also Article 360 itself. So for that, the amendment by special majority plus the state ratification also necessary. So these types of changes, if they want to make the time, the state ratification is necessary, we can say. Now, the important constitutional question was whether the parliament's power under Article 360 is unlimited or subject to restrictions. See here, judicial development of a parliament's amending power we can see by so many cases, decided landmark cases such as Shankari Prasad vs Union of India, that is the first case law relating to this in the year of 1951. So the fact of the case was the validity of the first Constitutional Amendment Act 1950 was challenged. So the Parliament has made one of the amendment to the Constitution by the first Constitutional Amendment Act 1951, and this was challenged by the amendment curtailed the rights to property to facilitate land reforms. So by this first amendment, the government wants to make such a laws and curtail this right to property. So the government wants to abolish the zamindari system. So for that reason, this act was this first Constitutional Amendment Act was came into existence, we can say, and this was challenged by the petitioner. The petitioner argued that the Parliament could not amend the fundamental rights because Article 13 Clause 2 prohibits the state for making laws that violate the fundamental rights. So the argument by the petitioner is that the first amendment or the abolition of zamindari system, it is against the Article 13 Clause 2 of the Constitution, because Article 13 Clause 2 says that state, it prohibits the state for making laws that violate the fundamental rights. It means Parliament cannot be make such a law which is against the fundamental right or which violates the fundamental rights, and it is clear-cutly violates the one of the fundamental rights, that is the right to property. Now the issue before the court was, can a Parliament amend the fundamental rights under Article 368? The judgment given by the Supreme Court held that Parliament has the power to amend any part of the Constitution including the fundamental rights, and the word law in Article 13 does not include constitutional amendments. And also court held that the constitutional amendment and ordinary law are different. So overall, in this case, the court held that yes, the Parliament has a power to amend the part of the Constitution including the fundamental right also, and the word law in Article 13 which does not include the constitutional amendments. So Article 13 says that a law which is against the fundamental rights, the word law is different from the constitutional. The constitutional amendment is not a law. Law is different. Constitutional amendment is different. That's why the first constitutional amendment is valid. So by this the court interprets here, and further court here said that constitutional amendment and ordinary law are different. So Article 13 ordinary law is different and constitutional amendment is different. That's why the first amendment, that is Constitutional Amendment Act, is valid, and Parliament has the power to amend the Constitution, also the fundamental rights. The significance of this judgment was the judge gave the Parliament very wide power, as we know. So by this the Parliament get a very huge and wide amending power, we can see here. But there are certain criticisms made by the author, that is the judgment was criticized for giving Parliament almost unlimited power over the constitutional rights. So, and that may be a chance of misuse the power isn't it? So later on, after some years, in the year of 1965, another case came before the Supreme Court, that is a Sajjan Singh versus State of Rajasthan. In the case of Sajjan Singh versus State of Rajasthan, the fact of the case was the validity of the 17th Constitutional Amendment Act was challenged. So here, the Supreme Court reaffirmed the decisions in the Shankari Prasad and held that Parliament can amend the fundamental rights. Article 360 includes the power of amendment, and the importance of the judgment is, although the majority upheld the Parliament's power, some judges expressed a concern that the fundamental rights should not be easily amended, and this case laid the foundations of the future reconsideration. So again, the Parliament has made a 17th constitutional amendment, and it was challenged by the petitioner. And in this case also, the Sajjan Singh versus State of Rajasthan, the Supreme Court reaffirmed the decisions of Shankari Prasad case. But this laid the foundations for the future reconsideration, because again, in the year of 1967, Golaknath versus State of Punjab case. In this case, the validity of constitutional amendments affected land reforms was challenged. So now the major question before the court is can a parliament amend the fundamental rights? Again, the judgment by 6 raised to 5, the majority, the Supreme Court reversed the earlier decision. That is a Golaknath case. So whatever the decision given by the before cases, that is a Shankari Prasad and Sajjan Singh case, in the Golaknath case, the court held that, or we can say the court reversed the earlier decisions and held that Parliament cannot amend the fundamental rights. Constitutional amendments are law under the Article 13, and fundamental rights are permanent and transcendental. We cannot touch it. So by this, totally reversed the judgment given by the Shankari Prasad and Sajjan Singh case. The court applied the doctrine of prospective overruling, and meaning previous amendments remained valid, but future amendments affect the fundamental rights were prohibited. So in this case, it is a prospectively overruling. It means it will not be retrospectively, but prospectively. In future, whatever the amendment made by the Parliament, it should be not valid. Whatever already the amendments made by the Parliament, these amendments were still valid, but in future, if the Parliament makes, these amendments will be considered as invalid. So again, the significance of this judgment is, the judgment greatly restricted the Parliament's power, we can say. So whatever the Parliament's power given by the earlier two judgment, that is the Shankari Prasad and Sajjan Singh case, so in this Golaknath case, it was restricted the Parliament's power, we can say. But it is also criticized by some judges. The judgment was criticized because it made the constitution too rigid and prevented the socio-economic reforms. So if you want to make any socio-economic reforms, we should be easy to amend the constitution. But if you made such a rigidness, it is highly impossible to amend them, and they cannot make any reforms or developments. So this is we can say that is a criticism or lackness of the judgment, we can say. So later on, after the Golaknath case, again the Parliament responds the 24th Constitutional Amendment Act in 1971, and to overcome the Golaknath, Parliament passed the 24th Amendment. So whatever the Golaknath case given the judgment, to come out from that particular judgment, the Parliament make a 24th Constitutional Amendment and overcome from this judgment. And it explicitly give the Parliament's power to amend any part of the Constitution, added the Article 13 would not be applied to constitutional amendments, and also made the president bound to give assent to the constitutional amendment bills, and this amendment restored the parliament's power again. So, but it means it is nothing but a fight between the parliament and judiciary. Here, by giving a judgment, the judiciary is saying that the parliament has no power to amend the constitution or fundamental rights. Again, the parliament makes a constitutional amendment act and they can reverse these decisions. So, but now the famous and very important landmark case, that is the Keshwanand Bharati versus State of Kerala 1973. This is a very famous case law, as we know. So the importance of this case is, this is the most significant case regarding the Article 368, we can say. Article 13 judge bench, the largest in Indian judiciary history, heard the case, and the issue before the court was, does parliament have unlimited power to amend the constitution? So judgment given by the 7-6 majority in the Supreme Court held, parliament can amend the part of the constitution, amend the fundamental rights. Parliament cannot alter or destroy or damage the basic structure of the constitution. Again, here in the Keshwanand Bharati case, the court held that though yes, the parliament has the power to amend the constitution as well as the fundamental rights, but the condition is it should not be alter or destroy or damage the basic structure of the constitution, and this gives the birth to the basic structure doctrine, we can say. So basic structure doctrine means although the court did not give an exhaustive list, it did identify the certain essential features, elements of the basic structures, as such as we know, supremacy of the constitution. It is also a basic structure, we can say. Rule of law, judicial review, separation of power, federalism, secularism, democracy, republic nature of government, and free and fair elections, independency of judiciary, and unity and the integrity of India, and also we can say the balance between the fundamental rights and the directive principles. Not only, and also we can say that is a limited power of amendments. So these are the generally we can say the ingredients for the basic structure of the constitution. So it means for these points the parliament cannot be amended which affects these points. It affects the secularism or federalism or supremacy of the law or judicial review or rule of law, or so many things are there. So overall the significance of the judgment is this case established that parliament's amending power is wide but not unlimited. The parliament has a power to amend the constitution, and this power was wide but not unlimited. There is a limitation. What is the limitation? That is a basic structure limitation. So that is one of the significance of this judgment, we can say, and it struck a balance between the constitutional flexibility and constitutional supremacy. So in this case we can say it balanced the constitutional flexibility as well as constitutional supremacy. So later on in the year of 1975, another famous case law, that is the Indira Nehru Gandhi versus Raj Narayan. The fact of the case was the 39th constitutional amendment attempted to place the elections of the prime minister beyond the judicial review. So in this case they are trying to or attempt to place the elections of the prime minister beyond the judicial review. It means that the judiciary has no power to check it. That is a election. So election commission has power and judiciary does not interfere. That are the matters which should not be interfered by the judiciary. But the judgment of the Supreme Court struck down the amendment and held that the democracy is a part of the basic structure, free and fair elections are a basic structure, and also the judicial review cannot be removed. So these are the important features of points, and it should be very useful and important to the democracy. That's why again the importance or significance of this judgment is this case strengthened again the basic structure doctrines, and it focus on the basic structure. So that's why the judicial review is essential, we can say. Another important case law, that is the Minerva Mills versus Union of India 1980. The fact of this case is again the 42nd constitutional amendment inserted clause 368 subclause 4 and 368 subclause 5, declaring that the constitutional amendments cannot be challenged in the court, and Parliament's amending powers is unlimited. So again the Parliament make another amendment to the Constitution and make a law that the 42nd Constitutional Amendment Act, and insert the article 368 clause 4 and 5, and says that constitutional amendments cannot be challenged in the court, and Parliaments have amending power, that is unlimited power. But again the issue before the court is, can a Parliament enlarge its own amending power? The judgment of the court was that the Supreme Court struck down these provisions and held that Parliament's amending power is limited, judicial review is a part of the basic structure, harmony between the fundamental rights and the directive principle is essential, and fourth one is the limited amending power itself is a part of the basic structure. So that's why again the importance of this case is, this case reaffirmed the Keshavanand Bharati's and prevented the constitutional dictatorship. So again another case, that is the Vaman Rao versus Union of India 1981 judgment. The court held that laws inserted into the 9th schedule before 24th April 1973 are valid. It means the Vaman Rao versus Union of India, it says about the retrospective effect of the constitutional amendment. So as we know, 24th April 1973 is the date which the Keshavanand Bharati case judgment date. So before 24th April 1973, whatever the amendment or whatever the subject inserted in 9th schedules are treated as a valid. But after that, if you made such any changes, that will not be considered as a valid, because the Vaman Rao, in the Vaman Rao case, it was held that laws added after the Keshavanand judgment can be reviewed if they violate the basic structure. So after 24th April 1973, if Parliament makes any laws which against the fundamental right or which violates the basic structure of the Constitution, the court has the power to review it, or the judicial review has with the courts, and court can check it. Though that is the another importance of the case, we can say. So main significance of the Vaman Rao versus Union of India case is this protect the constitutional supremacy, we can say. And last one is, that is the Coelho versus State of Tamil Nadu 2007. The Supreme Court held that even laws placed under the 9th schedule are not immune from the judicial review. If they violate the fundamental rights from the part of the basic structure, they can be struck down. Again, the significance of this judgment is no constitutional amendment can be escape judicial scrutiny. It means every constitutional amendment can be scrutinized by the judiciary, and it should be there. Check and balance must be there, because arbitrariness or misuse of the power can be restricted by these mechanisms. That's why the judicial review is one of the basic structure, we can say, and it is a very useful or important point. So overall, the present scope of the Parliament's power under Article 368 is, today the legal position of the Article 368 is Parliament can amend any provisions of the Constitution, amend fundamental rights, amend federal provisions with the state ratification, change constitutional provisions according to the changing needs, but Parliament cannot destroy the basic structure, remove the judicial review, abolish the democracy or secularism. Thus, the parliament's power is broad but limited. Again, if we go for the critical evaluations of this, the arguments in favor of the wide amending power, society changes with the time, and that the power should be with the parliament, and constitutional flexibility is necessary because as we need the changes in society, we should be amend the constitution, and that is one of the important points. And third one is parliament represent the will of the people, and they should be act according to the welfare of the state. So, argument against the unlimited power. What are the arguments against the unlimited power? So, arguments against the unlimited power. It may be destroy the constitutional identity. If the power is given to parliament, unlimited power is given to the parliament, there may chances it may destroy the constitutional identity, misuse the power, they can misuse the power. Second one is fundamental rights may become meaningless because if the power is given to the parliament unlimitedly, again they can misuse for their own interest. That is, the fundamental rights have no power, it becomes meaningless. As we seen in Indira Gandhi time, that is 1975, the fundamental power has been misused by the Indira Gandhi at that time. So, and another is it may be create a parliamentary dictatorship. As we know, if the powers given to any unlimited powers given to any body, there may be a chances of it becomes a dictatorship. So that's why we should say that it is unlimited powers is not so safe. So overall, the Supreme Court solved this conflict through the basic structure doctrine, maintaining a balance between the flexibility and constitutional supremacy. Here, the main thing is that. And that's why, lastly, I want to conclude that the scope of the Parliament's power under Article 368 has evolved through the judicial interpretation. Initially in Shankari Prasad and Sajjan Singh, Parliament enjoyed broad amending power in Golaknath, and the court restricts the parliament from the amending fundamental rights. However, the landmark judgment in Keshavanand Bharati adopted a balanced approach by allowing the parliament to amend every part of the constitution while prohibiting the destruction of its restriction. So, subsequent judgments such as Minerva Mills, Indira Gandhi, and Coelho further strengthen the constitutional limitations. Therefore, the Parliament's amending power under Article 368 is extensive but not absolute. And the basic structure doctrine acts as the ultimate safeguard of the constitutional democracy in India. Thank you very much.